I had the chance to read the motion, and they've put together a composite of issues that would cause me a little bit of pause. And I can explain all the various things that they've put together. The main focus of this motion, as opposed to the previous one a year ago, which the judge denied, is on the daughter's line of work. As you already said, the daughter does work with many, many high-profile Democratic candidates. She works on their social media. They put out a post, they get contributions. She, as an owner, gets a percentage of those contributions. So there is a statute in New York which says a judge must disqualify himself if a person known by the judge to be within the 6th degree of relationship, and a daughter is the 1st degree, has an interest that could be substantially affected by the outcome of the proceeding. So the question here is this daughter likely to profit, to benefit from the outcome of this proceeding? And you have to understand, it's not actual conduct that's worrisome. It's the appearance to a reasonable person that this judge cannot be fair and impartial given that relationship. So ordinarily, I would think that a benefit financially would be to a spouse because they share the income. This is an independent adult daughter. They don't share income. Mm-hmm. But according to this statute, the judge must recuse if she would substantially benefit from the outcome. So that's one thing that concerned me. But if you add to that a few other facts that are of concern, at least to me, was the judge's original contribution to President Biden 4 years ago, which he made himself, very small contribution, $35.
Yeah, I think it was $10, right?
$35, I'm told, $35. A small contribution, but he made it through ActBlue himself on the internet. He did give an interview where he said he wouldn't comment on the case, but then he said he's been intensely preparing and he wants to be fair and impartial, and justice is important. He and his daughter discussed the former president's use of social media, which the judge condemned in that discussion, and the daughter reported on it. The Office of Court Administration said the daughter's Twitter account ended a year ago, so any recent posts on that were not from the daughter. Yeah. And I kind of wondered why the Office of Court Administration was defending the daughter. So there, if you put all these together, is my point, it's certainly enough that maybe a reasonable person could have a doubt about impartiality. So I think it's kind of a serious motion. I realize it's 10 days before the trial and don't expect it to be granted.
You hear so many experts, frankly, from across the aisle say that this case won't stand up on appeal. Well, if the case won't stand up on appeal, why was it ever brought in the first place? Why was a judge whose family has gotten rich off of Democratic Party fundraising allowed to preside over this thing in the first place? And Republicans, Jesse, we cannot just sit on our hands. We can't just complain about it, as important as all of that stuff is. We have to be willing to fight back. We need to be subpoenaing Judge Merchan and his daughter. We need to understand what are the connections between big Democratic money and this sham prosecution. Did George Soros ever talk to Alvin Bragg about using his power to go after Donald Trump? We need to get to the bottom of it. And when we find wrongdoing, we need to be willing to actually punish it. That is the only language that I think these people are going to understand, is that if they do this, if they turn the American system of justice into banana republic garbage, they're going to suffer consequences for it. And if they don't, Jesse, it's not going to stop with Donald Trump. Banana republics never stop with the guy at the top. It's going to go after a ton of other Republican officials and conservatives unless we fight back.
And welcome back Inside the Law. I'm your host, Philip Holloway. Well, today we now know that Donald Trump was convicted by the jury in his trial that concluded yesterday in Manhattan. And a lot of people have been asking me, why didn't I do a stream yesterday? Well, there's a couple of reasons for it. And one of the main reasons was I had some obligations with my family I needed to take care of, but also, I wanted to give it some time. I wanted to sort of process it and think about exactly, okay, what has happened? How did we get here? How did this happen? And what comes next? And I started looking around, and I looked at people who are sort of experts on like prosecutorial ethics and judicial ethics. And it occurs to me, in my opinion, this verdict is, garbage in, garbage out. And so if the verdict itself is the outcome, if it's garbage, and I think it is, then it's only that way because of what the prosecutor in the case and what the judge in the case have turned it into. So I'm going to talk to you more about prosecutors, and I'm going to talk to you more about why I think the judge should have recused himself. And then we're going to take a look at what comes next for former President Trump as the sentencing and things of that nature have yet to come. So we've touched on those issues in earlier shows, and it was more of a hypothetical, but now it's starting to be real. Okay, this is the direction we know that it's going in. So what actually does come next? Welcome everybody here. Those of you who are new, this is Inside the Law. This is where we will bring you inside the real justice system. We will explore the things about the justice system that are good, the things that are bad, and the things that are ugly. And I will bring you the justice system that we really have versus the one that you might think we have from watching television. And if you're like a lot of people, and perhaps we have some folks here from outside the United States, it's not at all uncommon for me to look in our chat and see people from Europe or Canada or even places even far, far away like Australia. And so a lot of people will look at this scenario and they'll say, what in the hell is going on over there in the United States? I mean, if you don't have a justice system that's based, on fairness, that's led by honorable people who are objectively seeking justice, versus people who have their sights set on getting a specific individual American citizen. If you would just elect me to office, I will get this person for you, the one that we all hate. I'll get him. You just got to vote for me. So it occurs to me that this trial and the DA's office in Manhattan are not necessarily representative of all of America. So that's one of the things that I wanted to start out by emphasizing. This was an absolute disgrace of a trial and of a prosecution. And I would say the same thing if it were a Barack Obama or Bill Clinton on trial, because we just can't weaponize the justice system to go after a specific individual. And you can't, if you're the judge, you can't stand on the scales of justice, tipping them in favor of the prosecution, because that's it's illegal, it's immoral, it's wrong. And the bigger problem is that it creates distrust in our criminal justice system. It creates distrust in our juries and our courts. I've represented people before in trials, people who were actually innocent, and they say to me, I had no idea that the system could be this way. Well, we've all been living now sort of vicariously through Donald Trump throughout this trial, and a lot of us are starting to wake up and say, oh my God, this actually, this can happen. And when it does happen, the consequences are very real. Right. And Donald Trump is going to still have some consequences that he's going to be facing consequences, not for things that he did wrong, but things that the prosecutor and the judge have done wrong. 382 people. I love to see it at 3:34 o'clock in the afternoon on a Friday. Thanks for spending some of that time with me. Please take a quick second and hit the like button so other folks can help find this channel. I wanted to share with you, I'm going to take myself off of the screen just a minute. I'm still here, but I'm going to bring you something from, all right, this is a part of a speech from it was from Robert H. Jackson, former Attorney General of the United States. Okay. And what he says is that the prosecutor has more control over life, liberty, and reputation than any other person in America. His discretion is tremendous. He can have citizens investigated, and if he's the kind of person, he can have this done to the public statements and veiled or unveiled intimations, or the prosecutor may choose a more subtle course and simply have a citizen's friends interviewed. The prosecutor can order arrests, present cases to the grand jury in secret session, and on the basis of his one-sided presentation of the facts, can cause the citizen to be indicted and held for trial. He may dismiss the case before trial, in which case the defendant never has a chance to be heard in court, or he may go on with a public trial. If he obtains a conviction, the prosecutor can still make recommendations as to the sentence, as to whether the prisoner should get probation or a suspended sentence, and after he is put away, as to whether this is a fit subject for parole. While the prosecutor at his best is one of the most beneficent forces in our society, when he acts from malice or other base motives, he is one of the worst. He is one of the worst. So that's how Robert Jackson, former Attorney General of the United States in 1940, he described the prosecutor's power in those terms. So on the one hand, the prosecutor being so powerful, if they are wise and if they are equitable and fair in the way that they use and exercise that power, then they are one of the greatest things about our system. On the other hand, when they operate out of malice or other ill motives, bad motives, if they weaponize the system like Alvin Bragg has done against a specific individual, if they campaign and say, elect me as DA and I'm going to get Trump, or I'm going to get any other person that happens to be someone that is disliked in his community, then that's wrong. And that was what Robert Jackson, that was the point he was trying to make. And that was the danger that exists if you put the awesome power of being a prosecutor into the wrong hands. So you got that on the one hand. You've got, I think, Alvin Bragg acting with ill motives on the one hand. And then we've got Merchan, acting justice, or Judge Merchan. Why he's acting, I'm not sure, but this is a man who has donated money to Joe, and granted it wasn't much, but he donated money to Joe Biden, like a Stop Trump fund kind of thing, like $35, I think it was, but it's not the amount of the money. It was improper for him to do it in the first place. But then secondly, what it does is it shows where his heart and his head is. And he is in the camp of, I hate Donald Trump. And if his head is in that place, he has no business presiding over a case where Donald Trump is the defendant. Now, we have talked about what I'm about to go over with you before. This is a recent, I hope everybody can see it. This is a recent ethics complaint filed by Congresswoman Elise Stefanik, and it was filed on May 21st to the New York State Commission on Judicial Conduct. That's the ethics folks that are in charge of investigating and prosecuting ethics violations whenever they may occur. And what she is saying is that she's letting them know that there's this conflict of interest involving acting Supreme Court Justice Juan Merchan, who currently presides over the criminal case against President Trump brought by Alvin Bragg. If convicted, Trump faces a maximum of 136 years imprisonment. Moreover, he's the presumptive nominee of the Republican Party and for this November's presidential election. As such, not only are President Trump's interests at stake, the interests of all Americans are indeed at stake. I think she's right about that. Then she goes on to talk about the conflict issue, and it pertains to Merchan's daughter, who is the president of Authentic Campaigns, a group that represents Democrat politicians and political action committees. When Trump was indicted in Manhattan in April 2023, Representative Adam Schiff of California, who is one of Judge Merchan's daughter's clients and who was running for the Senate, he sent out a fundraising email on that basis requesting donations. And he said, "It is a somber moment and unprecedented for a former president to be indicted, but his alleged offenses are unprecedented. Trump will respond as he always does, playing the victim and blaming others for having the temerity to investigate him in the first place. So send me money. Okay, so you got Merchan's daughter representing people like Schiff out there raising money off the mere fact of this indictment. She goes on to point out that the Senate Majority PAC, which is also a client of Merchan's daughter, they lead the effort to elect Democrats to the Senate. They fired off a similar fundraising email, and it said, Donald Trump indicted by a Manhattan grand jury. This is an important moment for our democracy, but our work is not over. We must continue protecting the Senate majority from GOP extremists. Please rush in $10 to help defend the Senate. And she points out, the Congresswoman does, since this indictment, Schiff has raised approximately $20 million. The Senate Majority PAC raised approximately $73.6 million. So the clients of Merchan's daughter have raked in nearly $100 million. That's just off the fact of the indictment, and have used the indictment, a case over which her father, Judge Merchan, presides, as fundraising fodder. It makes common sense that if these groups make no money, then they can't afford to pay for services by individuals such as Ms. Merchan. The more money is raised, the more can be spent on Ms. Merchan's fees. See how that works? They raise money off Trump. They pay Ms. Merchan as a result. And so the money that they raise off of this indictment goes back into, at least part of it, back into the pockets of the judge's daughter. So in the introduction to this live stream, you saw a clip that was an interview on CNN by a retired judge, and she cited this section right here of the Rules of Judicial Conduct, Section 100.3E of the Rules of Judicial Conduct for the state of New York dictates that Judge Merchan should not preside over President Trump's case. Under this section, a judge is disqualified from a case when the judge knows that a person known by the judge to be within the 6th degree of relationship, and that's a wide net. So a daughter is within the 1st degree of relationship. Okay, so even if these were like cousins of the judge, it would still be improper. But here we're talking about his daughter, well within this range of 6 degrees, where with the daughter being the 1st degree of relationship. So that daughter has an interest that could be substantially affected by the proceeding. Okay, so if she goes on to point out, if Donald Trump is convicted, such as he was yesterday, such a verdict would provide a fundraising windfall for the Democrat clients of Judge Merchan's daughter, and by extension, Judge Merchan's daughter herself would make more money. She refers to, it was retired Judge Scheinlin. That was the person in the clip at the beginning of the show, a retired federal judge in New York appointed by Clinton. She raised concerns about Merchan's refusal to recuse in that CNN interview. And then they go on to quote what Judge Scheinlin said, and I don't need to, you heard it for yourself. She points out that, and this is a quote from Scheinlin, there's a statute in New York which says a judge must disqualify himself if a person known by the judge to be within the 6th degree of relationship has an interest that could be substantially affected. So the question here is the daughter likely to profit from the outcome of this proceeding? And you have to understand, it's not actual conduct that's worrisome. It's the appearance of impropriety, the appearance to a reasonable person that this judge cannot be fair and impartial given that relationship. And so the judicial ethics statute in New York requires Merchan to recuse himself, says he can't be the judge in this case. Congresswoman Elise Stefanik goes on to point out this is part of a troubling pattern of judicial misconduct by Judge Merchan. Okay. Indeed, we learned last Friday that your office privately cautioned him over his illegal political donations to Biden and other Democrats. This private caution has not deterred Merchan's judicial misconduct, as evidenced by this current complaint. Judge Merchan appears driven by Democrat partisanship and financial gain for his daughter. And this is not hypothetical stuff, folks. This is real financial gain for his real daughter. And now Trump has really been convicted by this court presided over by Judge Merchan. It is imperative that New Yorkers and Americans have confidence in the justice system. It goes on to say that this could obviously destroy confidence in the system. Judge Merchan's clear conflict of interest based on his adult daughter's financial state in this unprecedented criminal trial has badly damaged the court's appearance of impartiality. Judge Merchan's daughter stands to benefit. The more legally imperiled Donald Trump is, the more she benefits. Okay. So now we've got the context. All right. We've got the context for why the judge should not have been involved in this case, and also how the prosecutor has acted improperly every step of the way. So where am I getting with all this? Well, the point that I'm trying to make is garbage in, garbage out. We had a criminal prosecution that should never have been made because the prosecutor started out with malicious motives. He campaigned on, I'm going to get Trump. All you got to do is vote for me. I'm going to get Trump. All right. So that's part of the garbage. The other part is that this judge has no business being involved in the case, and he is as biased as the day is long. Let me share with you. I want to change screens here. On Twitter the other day, I pointed this out. I said, look, why did he hear his own motion to, here it is. Why did Judge Merchan rule on the motion to recuse himself? A different judge should have heard that motion. Okay. A different judge should have heard that motion. Why was a judge whose family has gotten rich off the Democrat Party fundraising be allowed to preside over this case in the first place? So that's the point. But my question that I raised here in this tweet was, why did Merchan himself rule on the motion? When the Trump team filed a motion to have him recused, he should have given that to another judge, but he didn't. He ruled on it himself, which even further, I think, points out his conflict of interest. There's another thing I want to share with you. I found this, Ellie Honig, a CNN legal commenter, has written a piece for The Intelligencer, and she weighs in on this and some really good stuff here. Okay. I'm not going to read all of it to you, but she points out that this case was ill-conceived, ill-justified. This was an ill-conceived, unjustified mess. Sure, victory is the great deodorant, but a guilty verdict doesn't make it all pure and right. Plenty of prosecutors have won convictions in cases that should never have been brought in the first place. Let me pause for a second. We hear all this discussion, right, about, oh, well, you've got to respect the verdict. Even Joe Biden's coming out, well, you got to respect the verdict. I don't have to respect it. Why do I have to respect it? I don't have to respect it if it's wrong. I don't have to respect it if it's a case that never should have been brought in the first place by a prosecutor who is acting with malice and presided over by a judge so conflicted that he doesn't know left from right or up from down. I don't have to respect what happened in that courtroom because it was disrespectful. It's not worthy of respect. Back to what she writes here. Plenty of prosecutors have won convictions in cases that shouldn't have been brought in the first place. But they won is no defense to a strained, convoluted reach unless the goal is to win now by any means necessary and worry about the credibility of the case and the fallout later. The following are all undeniable facts. The judge donated money, $35, but in plain violation of the rule prohibiting New York judges from making political donations of any kind to a pro-Biden, anti-Trump political operation, including funds that the judge earmarked for, quote, resisting the Republican Party and Donald Trump's right-wing legacy. It was earmarked for resisting the Republican Party and Donald Trump's radical right-wing legacy. That was what the judge's contribution was earmarked for. Same one that presided over this trial. Would folks have just been fine with the judge staying on the case if he had just donated a couple $100 to reelect Donald Trump, MAGA forever? Of course not. People would have demanded that he be recused for the same reason. DA Bragg ran for office in an overwhelmingly Democrat county by touting his Trump hunting prowess. He bizarrely boasted, falsely, she says, on the campaign trail, "It is a fact that I have sued Trump over 100 times." She says that is false, and she writes a disclosure here. Both Bragg and Donald Trump's lead attorney, Todd Blanche, are friends and former colleagues of hers at the Southern District of New York. They were all former prosecutors together. Most importantly, the DA's charges against Trump pushed the outer boundaries of the law and due process. Now, that's not on the jury, she points out. That's on the prosecutors who chose to bring the case and on the judge who let it play out as it did, which is kind of the point that I'm getting to in a roundabout way is don't be mad at the jury, because the jury was operating with really nowhere else to go. The judge literally corralled them into a situation where there was really nothing else they could do if they were following his instructions. Now, I do think that some of them could have been more, especially the two lawyers. They had to see what was going on. So at least those two had to have seen some of this. But nevertheless, I'm putting most of this on Bragg and Mershon. The district attorney's press office and its flacks often proclaim that falsification of business record charges are commonplace, and indeed the office's bread and butter. She says that's true only if you draw definitional lines so broad as to render them meaningless. The DA, of course, charges falsification frequently, and that's when they do fraud cases and anything else involving forgery or fake documentation. But it's not this kind of false record. This kind of stuff is never prosecuted. The charges against Trump are so obscure and nearly unprecedented, in fact, that no state prosecutor, listen to this, no state prosecutor in New York or anywhere else has ever charged federal election laws as a direct or predicate state crime against anyone for anything. None, ever. Even putting aside the specifics of election law, the Manhattan DA itself almost never brings any case in which falsification of business records is the only charge. Standing alone, these charges would be misdemeanors, which posed two problems for the DA. First, nobody cares about misdemeanors. But secondly, they have a statute of limitations of 2 years, and they expired on Trump's conduct, which dates to 2016 and 2017. So in order to inflate these charges to the lowest level felony, which is Class E on a scale of A through E, to electroshock them back to life within the longer felony statute of limitations, the DA alleged that the falsification of business records was committed with the intent to commit another crime. Here, according to prosecutors, this, quote, another crime was New York State election law, which in turn incorporates three separate, quote, unlawful means. And see, this is what we talked about this here the last few times that we've been together here inside the law. The judge gave them this choice. Okay, you can pick amongst federal campaign crimes, tax crimes, or falsification of even some other document. In other words, things that the grand jury did not put in the indictment. The judge said, all right, even though the grand jury didn't include this in the indictment, no probable cause was ever found by the grand jury that this element of these crimes, existed. But even since I'm the judge, I'm just going to graft it in here, and I'm going to say that you guys can go consider these three things. Any one of them will do, and you don't have to be unanimous, by the way. He said they can pick and choose from those three things for unlawful means: a federal campaign crime, a tax crime, or falsification of more documents. Now, this is the first, when he gave those instructions yesterday or the day before yesterday, I felt like, okay, it's all but a done deal now that they're going to convict him, because they don't have to be unanimous on what this unlawful means is supposed to be. She goes on to point out, inexcusably, the DA refused to specify what those unlawful means were. The judge declined to force the DA to pony up until right before closing arguments. Well, she says, so much for the constitutional obligation to provide notice to the defendant of the accusations against him in advance of trial. Those of you who are not new here inside the law, you've heard this before, because we've talked about it a lot. Due process requires that people who are charged with crimes be put on actual notice of what they're accused of so that they can properly defend themselves. You can't ambush them during the trial, and you certainly can't go all the way through the trial and then do it at the very end when you're sending the jury back to deliberate. In these key aspects, she says the charges against Trump aren't just unusual, they're bespoke, seemingly crafted individually for the former president and for nobody else. The Manhattan DA's office reportedly have called this the zombie case because of various legal infirmities, including its bizarre charging mechanism. It's better characterized, she says, as the Frankenstein case, cobbled together with ill-fitting parts into an ugly, awkward, but more or less functioning contraption that just might ultimately turn on its creator. Trump will appeal, which is his right, and he's certain to contest the inventive charges constructed by the DA. She says, I won't go so far as to say an appeals court is likely to overturn a conviction. New York law is broad and hazy enough to potentially allow such machinations, but he, meaning Donald Trump, is going to have a decent shot at reversal. I share that with you because it I think nicely encapsulates a lot of the things that we've been talking about in here over the last, several days, or certainly over the last several weeks. By the way, I see, since I've been looking into that, checking here to the chat, we have 1,130 people. Welcome. If you're just joining us, this is Inside the Law. I'm your host, Philip Holloway. We're going inside the real criminal justice system, and we're using today some of the things that we've learned from the Donald Trump trial in Manhattan to talk about ways that sometimes the system can break down. And when you have prosecutors and when you have judges who aren't interested in due process, then what you have is you have a system that doesn't work right. It does not work as it's intended. It might achieve the result that the prosecutor is going after. He said he wanted to get Trump. Well, he got him. All right. I'll do my best to try to answer any questions. Thank you, by the way, for the super chat, Tim. And if you have questions for me, if you would, I don't think we have any moderators in here today to help me flag and star these, but if you have a question, if you'll just write question, and then that way I'll see that it's a question. I know that you guys are also chatting with each other, but in making obviously some very good comments, I'm sure. But if you have questions, if you preface it by stating question, I'll do my best to try to answer some of those as best I can. All right. The question now is, what comes next? What comes next for former President Trump? So Manhattan is not the United States, of course. It's Manhattan. It's only Manhattan. So it doesn't necessarily represent or reflect how the system works or should work anywhere else. This particular trial was reprehensible in the way that it was put together and conducted and tried by the prosecutor and even the judge. But I don't think that that's representative necessarily of the entire legal system across America. I think that for a lot of the reasons that we've been talking about, there are lots of things that the judge did that constitute reversible error. In the law, you have two types of error. You've got reversible error, and you've got irreversible or non-reversible error. So if the judge makes a mistake, they don't expect judges to be perfect. So if the judge rules on an objection incorrectly or something like that, unless it has a real good shot at changing the verdict, it can be called harmless error. Okay, that was the other word I was looking for. It's got harmless error and reversible error. So some error is deemed to be harmless. There's plenty of error in this case, and lots of it, most of it, if not all of it, I think is reversible error. You need to look no further than Merchan letting in all of the irrelevant testimony from Stormy Daniels that had no relevancy whatsoever to the crimes that were being charged. The only thing it was there for was to slime Donald Trump. And we've recently seen in New York, as a matter of fact, Harvey Weinstein case, we saw that case get reversed because the judge let in too much stuff that was The prosecutor brought it only for one purpose, and that was just to unnecessarily slime the defendant. Okay, so we have lots of reversible error, I think. And, look, he's got to go through the state appeals process first. Now, what I was reading earlier today, the appellate division is, I think, majority of the justices in the appellate division are Democrats appointed by Hochul or some of the more recent governors in New York. In fact, I think I read that the chief justice in the appellate division was a Kathy Hochul appointee. And after that intermediate court of appeals, they have, the state, the Supreme Court is the trial court. Okay. It's the, I guess the Court of Appeals in New York is what we would think of as the state Supreme Court. Nevertheless, their top court consists of justices appointed entirely by Democrat governors. So if Trump, I think there's plenty of reason to think that the case could be reversed, but he's got to go through the process, and this is going to take years. They're going to be able to call him convicted felon, and they will. They're going to start fundraising using convicted felon in all their ads. It's already started. So it's going to be reversed, I think, ultimately on appeal. We may wind up even at the U.S. Supreme Court, but you've got to go through the state process, appeals process first. So that could be many, many years down the road. Some people are saying, can he go directly to the U.S. Supreme Court? And the answer is no. You can't leapfrog over the state process just to get to the federal, the top court in the federal system. There's lots of things that have to happen before it could even get there. So what does happen next? All right. Well, in very real terms for Donald Trump, he's going to be sentenced on July the 11th. By the way, I think, was it the 18th? A few days after is when the Republican National Committee, our Republican National Convention is in, I think it's in Wisconsin. Nevertheless, what if the judge puts him on probation and says, you're not going to leave the state, or you're on house arrest? You can't leave Trump Tower or Mar-a-Lago. Merchan could theoretically do that, guys. We'll talk about that again in a minute, because he could also do worse than that. Before the sentencing hearing, Donald Trump's going to have to meet with a probation officer who's going to do what's called a pre-sentence investigation. They're going to do a background check on the man. He's never been convicted of a crime. He's got a clean record, as we understand it. And the probation officer will make a recommendation to the court, like, how much jail time should he get? Or should he get straight probation? Should he get a suspended sentence, or just what should happen? There's going to be a recommendation made by a probation officer. It's not going to be a recommendation that's binding on the judge, but it's simply a recommendation. Now, yes, on paper, Donald Trump could get decades in prison for the felonies that he's been convicted of. To say that it would be ridiculous to throw the man in jail that's not strong enough words, but it's all I can find right now. But it would be absolutely ridiculous to put him in jail. I don't think I would put Merchan Pat. I think he wants to. I think he wants to put Donald Trump in jail because he wants to go down, I think, in the history books as being the judge who put Trump in prison. Even if it's for a weekend or a few days to make a point. I think that he wants to put him in prison. But assuming that he doesn't, then that leaves probation. And if you're on probation, you live by a set of rules. Probation is a jail sentence that you serve outside of a court, outside of a prison. And there are lots of rules. Rule number one is don't break any laws. Don't get arrested. Okay. Common sense things. But there's also things in there like you've got to report to your probation officer as they tell you to. You can't leave the state without permission. You might be subject to random screens for drugs and alcohol. You might be ordered to wear an ankle monitor. You might be ordered to house arrest, even things like that. All these are conditions that are under the control and the discretion of the judge. The judge can also suspend the sentence. He could order him to be in jail and suspend it, on some condition in which effectively you'd wind up with something in the nature of like no sentence at all. So the judge could do something like that. I don't think he's going to send him to prison. I don't think he's going to do nothing. So I think he's going to do something in between, which that leaves us only with probation. And the conditions of probation are going to be key here. How much control does Merchan want to? Is he planning on? How much control is he planning on? Exercising over where Donald Trump goes, when he goes places, who he sees, how he lives his life. That's what judges do when they have you on probation. They can control every aspect of your life. So can he keep him off the campaign trail? Is that what they're trying to do? I'm sure they would love a big part of that. Yes, they want to do that. So assuming that there's no jail sentence, the prospects of home confinement or even, going to jail on the weekends, things like that, could obviously be a big problem if you're a presidential candidate. But what if Trump's right now, he's winning. He's on the path to win the presidency again in November. How does it work, folks, if he puts him on probation under all these conditions and says you can't travel without permission and all this kind of stuff, and but the probationer is the president of the United States, and the man needs to travel around the world. Got a big plane for it and everything, Air Force One. How is this supposed to work? And I don't know the answers. I just know the question. I think that it could potentially be a very, very big problem. I don't know how we're going to deal with it, but we just have to wait and see, what Merchan thinks he's going to be able to get away with. The judge could tailor some kind of a sentence that maybe does a mixture of house arrest for some period of time. And of course, these things, as I mentioned, are going to have serious practical, logistical implications for the campaign and even for his presidency if he wins. So it's going to be awkward. We just don't know yet. We just have to wait and see what Merchan does on July the 11th. All right. We have 1,249 people in here. Thank you for all of you for being here. Welcome to Inside the Law. If you're just joining us, I'm Philip Holloway, and we're talking about what's next for Donald Trump and also how did we get here. I'm very interested to see, if you have questions now, I want to go ahead and start looking at the chat. I see it's very, very active. And so let's just dive right in. See, Laurie started this out with the word question, which allowed me to see it. We were believing that logic and justice would prevail in the trial, but it didn't. And she asked, am I concerned that they could put him in jail, even if house arrest only? Yes, I am concerned about it. Some lawyers, I had my friend Paul Morrow on here Inside the Law about a week ago, and he's a lawyer in New York, and he thinks it's just out of the question that that Merchan is not going to put him in jail. I am, on the other hand, I'm more skeptical. I believe that Merchan may very well want to do that. He wants to go down in the history books, I think, as the guy who got Trump. So I hope I'm wrong, but we'll see. We shall see. Great question. Great point. Sea Travel asks, how do I think it would affect the judiciary if judicial immunity is stripped on judicial misconduct? Well, judges should not have this absolute immunity for the things that they do. Look, the judge takes an oath of office, right? And that oath has to mean something. You got to promise basically to follow the Constitution and the laws. And if you go out of your way to not do that, there's got to be consequences. There has to be something other than just like an ethics complaint. Deborah asks, when Trump wins re-election, can he pardon himself immediately? So the answer in this case is no. This is a state prosecution. This is not a federal prosecution. The president of the United States has no authority to issue a pardon. But you know who does? The governor of New York. And I've heard speculation that she might eventually do that for the good of the country and that, so on and so forth. I don't think she's going to be inclined to do anything nice for Donald Trump. I think she hates the man. I think she's as far left partisan as they come, but she would technically have the authority to do it. And the next governor could. Maybe the next governor is more likely to pardon Donald Trump, but we'll see. Excellent point. All right. Let's find another question here. Janice points out Dershowitz believes that the appeals court is so corrupt that Trump cannot win an appeal there, and it may go to the Supreme Court. What are my thoughts? Well, I think that he might be onto something there. Yeah, it's full of far leftists, many of whom are judicial activists, and just like Mershon, I'm sure that they have. If you were to look closely, you'd find that a lot of them have probably donated as well to the same get Trump, anti-Trump causes that Mershon has. So there's probably a lot of them that have conflicts of interest as well. And so if that's who now they did reverse Harvey Weinstein, but see, Harvey Weinstein was no Donald Trump. He was only a sex offender. Donald Trump is Donald Trump. He's way, way worse to them in their minds, right? Being Donald Trump is the worst thing you could ever be. Being a mere rapist or sex offender, well, that's we can live with that, but you can't be Donald Trump, not in New York, not in the court system. Okay. So they did see fit to reverse the Weinstein case, but whatever happens with Trump is anybody's guess. We just don't know. It's going to have to play itself out, and it's going to be years. All right. By the way, while I'm finding the next question, thank you all for joining at 1,261 people. Hit the like button. It helps people find me. There's also ways to support the show. There's links in the show description that will help me continue to bring new and better content here inside the law. And thanks for checking those out. All right. Crystal Swagger Stick says, question, if he appeals, will he have to sit in court the whole time? No, unlike the trial, the appeals process happens largely on paper. Now you can have oral argument, but most of it takes place on paper, and it's not with the parties directly in a courtroom. So no, it's not like the trial. He's not going to be chained to it. Thank you for the super chat, by the way. Question, time for symmetric lawfare from red states. All right. So before I started this stream, I was on with Megan Kelly this afternoon, and this topic came up. And I'll tell you that she is in the camp that, well, it's time to fight fire with fire. My words, not hers, but I think that was essentially the point that she was making. Some other people, myself included, that she talked to, I don't agree. I cannot come in here and tell you guys that lawfare is wrong. I can't tell you that it's wrong to weaponize the justice system against a specific individual citizen the way that it was with Donald Trump. And I can't say those things and then say to you at the same time, it's okay to engage in payback. Because if it's wrong, it's wrong. It's wrong when they do it. And if the other side does it, it's wrong then too. We should not have the justice system weaponized, in my opinion, against our political opponents, period. But what we can do, this is what I said to her, you can go after the people that caused this. Okay. You can make sure that you, within all bounds of the law, whatever mechanisms of recourse exist, take them, use them, because the people that are accountable are the Alvin Braggs and the Juan Mershons of the world. Okay. And you can make sure that they are held accountable one way or another. And that is the way to deter this kind of thing from happening in the future. But I don't think turnaround is fair play. Some of you probably disagree with that. I'm sorry. I can't tell you that weaponizing the justice system is wrong because it happened to Donald Trump, and then say, okay, but when you weaponize it against Joe Biden or anybody else, it's okay. I can't do that. I've got it. It's basic stuff here. The law is supposed to be fair. The law is supposed to be applied neutrally, without bias, without prejudice, without those types of emotional passions that we see so often in politics. So I just can't. I don't agree that turnaround is fair play. I can't support it. All right. Isn't the Supreme Court considering presidential immunity now? So if they rule in favor of that and Trump wins the election, then the corrupt judge would not have any authority over him. So none of this stuff that he's been accused of in this New York case has to do with any presidential action. It's all personal stuff. So any presidential immunity that is given as a result of the case that's currently on appeal would not apply to this case. That's how I see it. But thank you for the question. Great question. I happened to see Fulton County, so I decided to see what Michael says. To relate this to Fulton County, activists, judges, and prosecutors are the worst to have. They're not interested in justice. They're interested in activism. And I would also add to that, they're interested in politics. But this is why Patillo would be a bad judge. And he's referring to, Robert Patillo, who was the lawyer who was running against Judge Scott McAfee here in Fulton County, but who did not win. And he was, Michael, your point out, he definitely would have been very partisan and biased. All right. Pull up the wrong one. We don't use evil for evil. All right, let's see. Cindy, thank you for gifting the membership to people. That's very generous of you. Let's see. We got to have some more questions in here. I've had a whole bunch of these things that flew by and I couldn't catch them. Question. Bush Gore went to the Supreme Court. Why not this over election interference? Well, Bush versus Gore, for those of you who may not be old enough to remember, in 2000, the state of Florida there was an election dispute having to do with how many votes were for Gore and how many were for Bush. And so there was this recount going on. They did hand recounts, they did machine recounts, they counted and they counted, they got different numbers every time. And, how states run their elections is all a function of state law. Very little, if any, of it is covered by federal law. It's all a state thing. And so the litigation that started in the courts took place in the court system there, the state court system in Florida. Think about how little time there is between the election day, which is usually early November, versus I think around the 15th of December is when the names of the official electors from the state have to be sent into Washington. So you don't have a lot of time to get an election dispute resolved in the court system in Florida, and still get your electors sent to Congress on time, at least the names. And because there was this hard deadline and it was fast approaching, and I forget how many days away it was, but it was getting really close. The Florida Supreme Court had ordered another recount that was not going to get finished in time. In other words, Florida would have not been able to submit any electors at all to the Electoral College. And so the Supreme Court, there was an emergency appeal filed, and the Supreme Court agreed to take it, said that there was enough of a federal question there because this constitutional deadline was days away. And so they decided we would weigh in, and they ordered a halt and a stop to the recount. They said, we'll just go with whatever numbers you've got now. And that was 24 years ago, and I'm doing that basically by memory. So if I got some of my facts wrong, forgive me, but essentially that's how it went down. All right. So in this case, I don't think that we have I don't think we're there yet. I don't know that the Supreme Court can find federal jurisdiction here because Donald Trump's not even the nominee of the party yet officially. Okay. So it's just not right. That's an excellent question. And there, I can tell you that people are thinking now about ways in which to perhaps get the federal courts to take a look at this. And it's something that I know scholars and lawyers who represent the parties even are trying to figure out if there's any potential way to get creative and get this into the federal system. I don't think they will, but it may be worth a shot. Prophecy says, my question was about red states going after real criminals. Okay. All right. Maybe I misunderstood you. The ones doing all this, we don't need to concoct charges. So it's an excellent point. And Alvin Bragg was on a mission to get Trump. Okay. He literally campaigned on, I'm going to get Trump. And in order to get Trump, Trump's not out there committing carjackings and shooting people and doing all the other things that happen on the streets of Manhattan every day. Hell, he wasn't even living there. He's in Florida. Okay. So Alvin Bragg had to figure out, get creative, find some way to get Trump. So he come up with this cockamamie charges, cobbled them together in some crazy way. By the way, we still don't know. I can't tell you what the jury said that Donald Trump is guilty of, because, they had those three choices. The verdict form didn't even identify what unlawful means they said that he used. So as we sit right now today, we still don't know exactly what the jury said that he did wrong. But yeah, going after, I think Alvin Bragg and the Fannie Willis's of the world would be much better served to look to the streets of their communities and help take care of real crimes, things that impact people's lives on a daily basis there. I think that's very, very good. Very good point you made. All right. Let's find some other. Here's a question here. Chat's moving so fast, it's hard for me to flag these. All right. If Republican attorney generals know the crimes have been committed in their state, i.e. Jim Biden's part in alleged Medicare fraud in Florida, do you think they should go after him, or is that lawfare? Well, okay. So a few minutes ago, I said, turnabout. We don't need to engage in the same thing because they did it. Okay. If it's wrong, it's wrong. If it's wrong to politicize the justice system against Donald Trump, it's wrong to do it against anybody else either. So it would be wrong to politicize and use a case against a family member of the president if you're doing it for political purposes. Now, that being said, if I know that Medicare fraud is something that is routinely prosecuted by the federal government and also by states. So these types of fraud are things that are typically prosecuted. And if a solid case of Medicare fraud happens to come across somebody's desk, they should not ignore it either for the same reasons. So what I'm saying is they don't need to go out and say, okay, I'm going to get this person. Now I got to figure out how I'm going to do it. Okay. That's what they did with Trump. He got elected to get Trump. So then he's got to go figure out a way to get Trump. And I think Fannie Willis is doing the same thing in Atlanta. So I'm not suggesting that we do that, but if you're the prosecutor in office and a case is made by law enforcement, and it comes to your desk and it just so happens to involve Jim Biden and the evidence is overwhelming, and look, and these prosecutors routinely prosecute this kind of fraud, fine, go for it. But don't single out a Jim Biden or anybody else and say, okay, we're going to figure out a way to get them because they went to get Trump. We're going to go after these people and play the tit for tat. That's sort of the distinction that I was trying to make. All right. I see the chat is just moving really, really fast. Try to flag a couple of more questions. Couldn't the Supreme Court take it up since Merchan invoked the in the FEC instruction? No, I still don't think that's the case itself is not a case based on federal law. This is a case, so there is no federal hook. The federal courts themselves, the Supreme Court is just one. You've got the trial courts and the appeals courts. The courts in the federal system are only there to adjudicate disputes that arise under federal law. Okay. And so this is a state law violation here. Now, you can raise as part of your defense that they violated my Fifth Amendment, Fourth Amendment, Sixth Amendment, whatever, some constitutional rights. And yes, that's a federal hook. And so what happens is you go through the state appeals process. And if you're unsuccessful, then you can start what's called a collateral attack. That's the habeas type of thing. But you start all over and you file your habeas petition in a federal trial court alleging that the state prosecution of me violated my constitutional rights in some way. Then you go through the trial court, then you go to the Court of Appeals, and then if it's a really serious issue and you're really lucky, you'll get the Supreme Court to take it. So you got a lot that has to happen before it could even get there. So when I see people on social media saying, "Oh, we can get it to SCOTUS in no time," no, you can't. It's just not how it works. It's not how it works. All right, guys. Like I said, I'm trying to answer as many questions as I can. If Trump is elected and doesn't abide by the terms of his probation, can he get arrested while he's serving as POTUS? Maybe. What you guys tell me in the chat? What do you think? So normally, if someone is on probation, rule number one is don't break any laws. Okay, don't break any laws. And so if you do break a law, then what happens is you're in violation of probation. They can issue a warrant for your arrest, put you in jail, and if it's bad enough, they can revoke whatever time is left on your probation. So let's just say you got 3 years on probation. You go out tomorrow and you get arrested for driving under the influence of alcohol or something, and they violate your probation. They can make you serve the whatever remainder is left, 2 or 3 years of it, in jail for violating probation. So the question is, could that happen to a sitting president? So if a sitting president is on probation in New York and he commits some crime that Judge Merchan or Alvin Bragg becomes aware of, they file a petition to revoke his probation. What would that look like? And the answer right now is I don't really know, because we are in uncharted territory here. This is sort of the nightmare scenario that I've been thinking about, and I talked about earlier in this live stream. If Donald Trump is on probation and he wins the presidency, how much control is Merchan going to exercise? Is he going to say, it's a standard condition of probation that you don't leave the state without permission from your probation officer, which also means you don't leave the country. So if you're the president, you got to travel from state to state to state and all over the world. Are you going to have Juan Merchan telling the president of the United States, no, you're not, don't you set foot on Air Force One, Mr. President, or I'm going to lock you up? It's just a scenario that is so ridiculous that I can't believe we're absolutely having to have a conversation about it as if it can happen. But it can happen, and we may be headed to this ridiculous place. It's just asinine. It's asinine. And yeah, true. This is like a nightmare kind of. It makes my head explode just thinking about how it would work. I have no idea what the Secret Service. See, the Secret Service apparently is working out contingency plans in case Merchan throws him in jail. He doesn't lose his right to Secret Service protection unless Congress changes the law, and they're probably trying to do that. I think I heard something about that anyway. But the Secret Service is trying to figure out how they can accommodate Trump at Rikers Island if that's what Merchan wants to do. It's just nuts. We're living in bizarro land. All right. Anyway, so that's my thoughts, and that's my breakdown of what's going to happen next. We're obviously going to have to watch this very, very, very closely. July the 11th is the date when he's going to be sentenced. One thing that the judge can do, it's called a conditional discharge. It's something, admittedly, I'm not a New York lawyer, so I'm not that familiar with it, at least in the way that the phrase is used in New York. But as it has been explained to me by colleagues who are New York lawyers, the way it would work is the judge basically says, all right, for X number of weeks or months or whatever, don't get in any trouble, and then we'll, essentially it's going to be discharged, and the case is, it's not like a dismissal, but it kind of is, but it's like not even sentencing him to anything. It's like a watered down probation kind of situation. So he could do that. Maybe that's what he should do. Maybe that would be the easiest thing, because look, if all they want to do is label him a convicted felon for the campaign ads, they've already got it. So I think that if they were to try to push it and impose, serious house arrest or even jail, I think that it's going to create such a public backlash that it's just not going to be practical. But Again, I don't know. We're just gonna have to watch this and see. I mean, what if they try to put him on probation and say you can't go to the convention 4 days later? Or what if he puts him in jail for a week and it coincides with the convention? I mean, all these things are, maybe some of them are more likely than others to occur. Maybe it's unlikely that could come to pass, but it's not beyond the realm of possibility. And it's just so crazy that we're sitting here right now, even having this discussion about it. There's one other question here. Can he leave New York City now, or does he have to wait until sentencing? I think he can leave. I think he's under the same rules that he's been under until sentencing, but I don't know that for a fact, but I think that's probably the case. All right. Yep. Someone mentioned that the campaign, I think that's the number I heard, but it's overnight. There's a lot of people that have said to themselves, you know what? I wasn't a big Trump fan. I might have leaned to, more to the right than to the left, but after seeing what I've seen, they're now 100% in the Trump camp and are donating a lot. And it's small donations too that are really piling in there. All right. Let's see what somebody, Aston says, started watching during the Fannie Willis fiasco in Georgia. Well, thanks for watching, Aston. Tell all your friends to watch. By the way, I'm trying to get to 35,000 subscribers. I'm at 31.6 and some change. So tell all your friends and your family, anybody you know that might be interested, subscribe to the channel. Help me out. And by the way, Aston, the Fannie Willis fiasco is not over. We've got oral arguments coming up on the disqualification issue. That should be in October. August. I think maybe by October, November, we might get a ruling on that. So it's not over at all. All right. This thing's moving so fast. I think Trump can immediate appeal restrictions to appellate court. And since he is always in the presence of Secret Service, he's obviously not a flight risk. So certain things can be appealed, like the gag order is being appealed. But any sentence is going to be, it would have to be part of the appeal of the whole case. And you're going to have to send the record, which includes all the transcripts of all the testimony and everything and all the exhibits. It takes a while to put all that together. In any event, he's going to get to the Court of Appeals, but I've been telling people for 25 or 30 years, you don't put your eggs in the appeal basket, because you're likely to be very, very disappointed. If you're going to win, you got to win it at trial, because if you put all your hope, but we're beyond that now, so he's got to do the appeal. But I don't have a lot of faith that appeals courts are going to do it, because if you think about it, part of the appeals court's job is to not reverse the lower courts. In other words, once your case gets up on appeal, you're not presumed innocent anymore. Okay, like you are at a trial level, you have the presumption of innocence. But once a criminal case is up in the Court of Appeals, there's a lot of presumptions that cut against the defendant. And so the appeals courts have a tendency, if you look at the statistics, I don't know what they are, but by and large, the vast majority of cases affirm the trial court. That means they do not reverse the trial court. They leave the trial court ruling intact. And by that, I can also mean the conviction. All right. So I just don't put a whole lot of, I've heard this before too. Appeals are for losers. That's right. It's the losing party that goes up on appeal. And I would, that's all. If that's all you've got, that's all you've got is the Court of Appeals. And so at this point, that's all he's got. He's got to put the case up on appeal. And I think eventually it will get overturned. It just won't be this year. All right, guys, we've been at it over an hour. I'm going to have to go ahead and leave it there, but I want to say this before we go. I appreciate each and every one of you. I feel that this is some of the best chat discussion that you're going to find. I like to go back and watch after YouTube processes all this. I'll go back and I will watch the replay of the live chat because I missed so much of it. I find that you guys are very entertaining, and there's a lot of things I learned too from watching the comments and then things in the chat. So thank you all very much for being here. I hope you have a great rest of your Friday. And until next time, we'll see you right back here inside the law as soon as we have any more movement on this case.